Mr. Deputy Speaker, everyone in the House will concur that the issue of long-tailed macaque has prompted heated debates. There are indeed a number of valid, legitimate, sensitive but conflicting interests which are at stake. For a sizable number of animal lovers and militants in favour of the welfare of animals, the trading of long-tailed macaque should stop. Under international law, exportation of monkeys is lawful and is regulated by the Convention on International Trade in Endangered Species of Wild Fauna and Flora, whereby monkeys, breeding companies are issued a site-specific export permit for all consignment being exported. From a biodiversity perspective, long-tailed macaque are an invasive species which has been negatively impacting the local native endemic and endangered biodiversity. From an anthropocentric angle, these long-tailed macaque constitute a danger to our agricultural farm and sometimes to the safety of citizens. Mr. Deputy Speaker, there is no short or long-term policy to date. In this context, a committee is being set up with all concerned stakeholders, including inter-alia ministries, academia, NGO and the private sector, to look into all the aspects pertaining to exportation of monkeys. Any decision on the matter will be taken collectively with concerned stakeholders, subject to the agreement of government acting in public interest.
Okay. Honourable Second Member for Flag Bonakai.
Mr. Deputy Speaker, Sir, B219, please.
Monsieur le Vice-président, j'ai été informé par la Central Water Authority que la mise en œuvre des projets de remplacement des tuyaux proposés dans les villages de Palma, Quatre-Coco, Bellemare, Mort-du-Puy a rencontré plusieurs défis. L'appel d'offres lancé par la Central Water Authority pour le renouvellement des tuyaux dans la région de Quatre-Coco a dû être annulé 3 fois en raison d'offres non conformes à 2 reprises et d'un prix d'offres élevé à la 3e occasion. Monsieur le Vice-président, je suis en outre informé par la Central Water Authority que le contrat pour le renouvellement de 1,5 km de tuyaux existant dans le village de Palma a été attribué à Great Standard Solution Limited pour la somme de 8 500 000 le 31 mai 2024. De la même manière, un autre contrat pour le renouvellement de 1,5 km de tuyaux à Mort-du-Puy, Quatre-Coco, le contrat a été attribué à Solcon Limited pour un montant de 9,9 millions de roupies le 18 septembre 2024. Les 2 projets n'ont pas pu être mis en œuvre. La CWA, comme je l'ai dit la semaine dernière, la CWA n'ayant pas respecté les dispositions de la loi sur le marché public en attribuant des contrats dont les montants dépassaient la valeur approuvée dans le projet. En bref, les 2 contrats ont été attribués alors que les fonds n'étaient pas disponibles. Monsieur le Vice-président, comme je l'ai expliqué, comme je viens de dire la semaine dernière lors de notre session du 18 mars, des irrégularités ont été constatées dans la mise en œuvre des projets de remplacement de tuyaux au niveau de la CWA. Dans le budget 24-25, le montant approuvé pour le projet, petit projet jusqu'à 3 km, qui implique le remplacement de tuyaux d'une longueur de 1 à 3 km, s'élève à 1 milliard de roupies. Le projet, valeur de 1 milliard de roupies, réparti sur 3 exercices financiers. En 2023 et 2024, la CWA a attribué des contrats de remplacement des tuyaux à des petites et moyennes entreprises pour un montant supérieur à 1 milliard de roupies. Comme je disais, des contrats l'année dernière, à la veille des élections, des contrats distribués ici et là. Ce qui est contraire au principe du marché public. En règle générale, les contrats ne devraient pas être attribués que lorsque les fonds sont disponibles. Monsieur le Vice-président, je suis informé que la valeur du projet a augmenté dorénavant de, comme je l'ai dit, 1,595 milliards de roupies, donc 595 millions de roupies en dépassement. Mon ministère devrait désormais s'adresser au ministère des Finances pour demander une augmentation de la valeur du projet et solliciter l'approbation du gouvernement sur la valeur révisée du projet de 1,5 milliard à peu près, conformément aux procédures en vigueur pour le projet d'investissement. Ce n'est qu'à ce moment que la CWA pourra procéder à la mise en œuvre d'autres projets de remplacement de tuyaux, par des entrepreneurs de petite et moyenne taille, y compris les deux mentionnés par l'honorable député.
Yes, Honorable.
Monsieur le vice-président, puis-je demander à Monsieur le ministre, dans la mesure du possible, d'accélérer ce projet parce que les gens qui habitent ces régions sont obligés de boire de l'eau des tuyaux qui sont infestés d'amiante. Donc voilà, c'est une question sanitaire. Voilà, si vous pouvez prendre cela en considération.
Bien sûr, Monsieur le Président, nous avons déjà fait une demande auprès du ministère des Finances pour augmenter ce plafond-là. Mais vous savez, avec la CWA, il faudra avoir pas 2 yeux, mais 4 yeux pour surveiller ces gens-là. Mais je ne manquerai pas de voir ça.
Yes. Honorable Third Member for Beaubassin, Petite Rivière.
B220.
Mr. Deputy Speaker, sir, at the very outset, I wish to inform the House that the situation at the Mauritius Football Association was one of the most pressing issues that demanded my immediate attention upon assuming office. I was deeply concerned by the reports circulating in the press and felt it was imperative to address the matter without delay. To gain a comprehensive understanding of the situation, I promptly requested a full and detailed brief on the issue, particularly whether the election could be held. Mr. Deputy Speaker, sir, it is important to distinguish between the election that was held at the Mauritius Football Association and the eligibility of Mr. SS to stand as candidate. These are two separate issues. One does not preclude the other. Mr. Deputy Speaker, subsequently my ministry obtained a copy of the court ruling on the case of Mr. SS through the Ministry of Foreign Affairs. Thereafter, the advice of the Attorney General Office was sought, and the latter indicated that Mr. SS could be considered as eligible to stand as candidate to the National Managing Committee of the Mauritius Football Association. Mr. Deputy Speaker, with regard to Part A of the question, I'm informed by the Mauritius Football Association that all procedures were followed as per the statutes and rules of the Mauritius Football Association Electoral Code. In fact, in the process leading to the election held on 27 November 2024, I'm informed that the Mauritius Football Association must adhere to strict and well-established procedures. Specifically, the MFA was required to publish a notice of the election in newspapers, which was duly done on 12 October 2024 in Le Défi Plus Daily. Additionally, the Mauritius Football Association was obligated to issue a further notice 10 days prior to the elections, confirming that the election would proceed as scheduled together with the official list of candidates. This requirement was also fulfilled in Défi Plus of 16 November 2024. The election was conducted under the supervision of representatives from FIFA and the African Football Confederation, and at the local level, Mr. DM, a retired superintendent of police, was entrusted with the responsibility of overseeing the electoral process. With regard to Part A1 of the question, I'm further informed that only 2 individuals submitted their candidacies for the position of President, Mr. SS and Mr. ER. As for Part A2 of the question, I'm also informed that in accordance with the statutes of the Mauritius Football Association, any candidate for the position of President must be supported by at least 5 members. Unfortunately, Mr. ER was unable to secure the required level of support, whereas Mr. SS successfully met this criterion. Mr. Deputy Speaker, concerning Part B of the question, I'm tabling, with your permission, the composition of the current Managing Committee of the Maurice Football Association for the information of the House. Mr. Deputy Speaker, I wish to inform the House that while I'm fully prepared to report on matters pertaining to Sport Federation in relation to the obligation under the Sport Act 2016, it will not be appropriate to report on their internal affairs as such. The Sport Federation are autonomous entities similar to many other associations that receive various forms of support from the government, such as I can only report on issues pertaining to the federation that falls under the purview of the Sport Act 2016. In the meantime, Mr. Deputy Speaker, I would like to highlight that the Sport Act 2016 provides comprehensive provision for any individual who feels aggrieved by the action or omission of a sport federation. The Sport Arbitration Tribunal, an independent body established under the law, is specifically tasked with addressing such matters. Therefore, any aggrieved parties have the right to refer their concern to the Sport Arbitration Tribunal for appropriate redress. Mr. Deputy Speaker, sir, my ministry will not walk away from its responsibility of bringing order to the catastrophic situation which I inherited in the sports sector. We will bring order to this disorder. We are already working on the introduction of the National Assembly of a new sport bill that will address many of the seemingly unresolvable problems. I wish to conclude by stating that I will not condone any form of malpractice from any national sport federation which may jeopardize the interests of the sport community. Thank you, Mr. Deputy Speaker.
Yes,
Merci, Monsieur le Vice-président. Permettez-moi tout d'abord de dire que je suis en total désaccord avec ce que vient d'affirmer l'honorable ministre par rapport aux procédures suivies lors des dernières élections. Monsieur le Président, je me demande ma question est, comment le ministre peut-il justifier la candidature de quelqu'un, Monsieur SS, qui a été condamné à 1 an de prison avec sursis et une amende de 900 000 ayari pour violence physique, psychologique et morale à l'encontre de son épouse, alors que la Sport Act 2016, la loi suprême du pays en matière de sport, est claire là-dessus, et je cite rapidement la section 9.5c. No person, Monsieur le Vice-président, shall be eligible for election as a member of a managing committee of a national sports federation where he has been sentenced to imprisonment by a court for an offense. Donc, comment une personne condamnée peut être candidat à une élection fédérale? Et je vais déposer, Monsieur le Vice-président, copie de l'acte de condamnation de M. SS, accompagné d'une copie de la section du Sport Act que je viens de citer.
Is it a certified copy of the judgment?
Bien sûr.
I'm asking, it's a certified copy.
Donc, vous pourrez jeter un coup d'œil si vous le voulez.
Honorable Minister?
Yes. In view of the Attorney General Office, in respect of the ESS election as follows, since Section 9.5c of the Sport Act simply refers to a term of imprisonment and is silent regarding, for example, a suspended sentence, peine d'emprisonnement avec sursis, a sentence whose execution is suspended pending appeal, etc., an interpretation of Section 9.5 could be that it was intended to apply to a person who is actually made to serve a sentence as imprisonment. Hence, on the basis of the above, it may be said that Mr. S could be considered as eligible to stand as candidate, as a state office stated.
Je suis totalement, encore une fois, en désaccord. En plus de la Sport Act, qui a été transgressée avec l'accord de l'honorable ministre lui-même, il y a également le questionnaire for integrity checks de la MFA qui stipule à la section 1.4a, et je cite rapidement, An integrity check shall be deemed as not passed if the candidate concerned has been subject to criminal conviction or disciplinary sanctions by a state court, in particular if the underlying behavior was a substantive issue and not a minor infraction or procedural behavior. Avec cela, ce qui fait que la transgression de la loi du pays, il y a aussi des règlements internes de la MFA. Est-ce que, Monsieur le Vice-président, l'honorable ministre, considère-t-il pas que M. SS, après que j'ai énuméré tout ce qu'il y a contre M. SS, qu'il n'était pas qualifié pour être candidat à cette élection et de surcroît assumer la présidence?
The Honourable Minister has already been answered. The Honourable Minister has stated that he is going according to legal advice, and he has acted on legal advice submitted to him. So we can't in this House challenge legal advice. So I take it that the answer has already been forwarded to you.
One last question.
Yes, but we can't challenge the legal advice upon which the Honourable Minister is acting.
Je vous comprends. Donc, pour clore sur ce dossier, Monsieur le Vice-président, le ministre a parlé des conseils qu'il a pris, qu'il aurait reçus avec la State Law Office ou le bureau de l'Attorney General. Peut-il donc déposer une copie des échanges qu'il y a eu entre son ministère et la SLO et le bureau de l'Attorney General, incluant...
Of course, I'm prepared to lay any document that related to that.
This is the document between lawyer and the institution is privileged document which cannot be laid on the table of the Assembly. It's a privileged document between the client and the attorney.
I did by what the Deputy Speaker said.
No, sorry, what did you say? Okay. Sorry for the Vice-President. The Honourable First Member for Rodrigues.
Thank you, Honourable Deputy Speaker. Question B221, please.
Mr. Deputy Speaker, sir, I am informed by the Information and Communication Technologies Authority that two mobile operators, namely Cellplus Mobile Communications Limited, a subsidiary of Mauritius Telecom, and MTEL Limited, operate networks in Rodrigues and provide mobile network internet services. As at date, Cellplus Mobile Communications Limited and MTEL have 23 and 16 base stations respectively and have deployed 5G offering a maximum download speed of above 100 megabit per second in Rodrigues. Moreover, both Mauritius Telecom and MTEL provide home broadband internet services. Mr. Deputy Speaker, sir, as regards the quality of the internet in Rodrigues, I am informed that ICTA carried out between 30th June 2024 and 6th July 2024 an assessment exercise of the broadband to test the quality of service. The tests were conducted principally on the 4G mobile network that were deployed by both the operators. And this covered 92 locations. And that actually those 92 locations, they cover a majority of the inhabited regions of Rodrigues. Although the assessment exercise concluded that the mobile internet coverage was satisfactory across majority of the areas in Rodrigues, several regions such as Songe, Roseau, Rivière Banane, Pointe du Diable and Rivière Pistache still suffer from poor coverage. And that is due to the topography of Rodrigues, which is a challenge actually to ensure maximum coverage. Therefore, MTEL has informed that 2 new mobile sites will be implemented during the course of 2025, namely at Mang and Rivière Banane. However, the long delays in securing clearance from the authorities in Rodrigues are hampering the setting up of additional sites at the moment. As far as connectivity by Cellplus Mobile Communications Limited is concerned, a major network upgrade was undertaken in 2024 in order to enhance 4G services across all the existing sites and for the deployment of 5G network on all the sites. As part of its 25-26 expansion strategy, CellPlus is planning the deployment of new sites. And the regions that will be covered are as follows. Baladirou Technopark and Port-Maturin. This will be done by September 2025. Montplaisir and Grande Montagne, which will be done by November 2025. And L'Union, which will be done by, which is due February 2025, which just passed. And that should have been covered. CellPlus Mobile Communications Limited has requested assistance from local authorities in Rodrigues for facilitation of space and permits that are needed for the installation of infrastructure and locations that are aforementioned. CellPlus has also informed that replacement and service restoration are undergoing, and this is being done at Mont-Lubin and are expected to be completed by May 2025. Finally, ICTA is currently implementing a quality service measurement platform that will allow any subscriber to test its internet service subscription and to communicate the results through an app deployed by the ICTA itself. In this respect, the ICTA will continue conducting regular quality of service measurement campaigns in Mauritius and Rodrigues too, and will publish comparative performance of different broadband internet service providers. It is believed that this measure will empower consumers to make informed choice of services and service providers, and will motivate the internet service providers to improve their quality of service and in the interest of subscribers. Thank you.
Yes, Honourable Fatwa.
Just one supplementary. I thank the Honourable Minister for this extensive answer. May I ask the Honourable Minister whether he is aware that in 2023 there were 2 major technical equipment failures at the level of Mauritius Telecom in Rodrigues, causing disruptions of services thereat. May I know from him whether there is any backup plan or link or redundancy plan for Rodrigues if any failures arise again in the future?
So, because the question was focused on the quality of service currently, not on the redundancy of service, the answer focused on the quality of service. With regards to the redundancy of service, I will revert at a later stage. Thank you.
Honourable Second Member for Mayberg and Planmayon.
B222. Mr. Deputy Speaker, sir, I'm informed that as at December 2024, a sum of 154,789,022 rupees has been disbursed by the Ministry for the operation, management and payment of the annual license fee in respect of the Liverpool Club International Academy. Mr. Deputy Speaker, I am informed by the Mauritius Multisport Infrastructure Limited, a state-owned private company that has been entrusted with the responsibility for hosting the Liverpool Club International Academy, that since in inception in 2019, the latter has produced the following result. First, the enrollment of 650 trainees, out of which 75 are playing in national leagues. Second, 38% of the under 20 COSAFA men's team were Liverpool Club International Academy training, and 50% under 17 boys team were Liverpool Football Club International Academy trainees, 20% under 17 girls team were Liverpool Football Club International Academy trainees, and 24 Mauritian coaches have successfully completed the Liverpool Club International Coach Accreditation course.
Yes.
I was hoping that one day we see a Mauritian player at Anfield, but I don't think so. But will the Minister state to the House when the contract was signed, the duration of the contract, and if this contract will be reconsidered?
Mr. Deputy Speaker, the contract was signed in June 2019 between Mauritius Multisport Infrastructure Limited and Liverpool Football Club and Athletic Grounds Limited The contract is due to expire 31st May 2025. So government has decided that the existing agreement between Mauritius Multi-Sport Infrastructure Limited and Liverpool Football Club and Athletic Ground Limited will not be renewed upon its expiry. The Mauritius Multi-Sport Infrastructure Limited has been requested to work on winding up procedures and arrangement. The Ministry of Youth and Sport is presently working on suitable alternatives that will replace the Liverpool Football Club International Academy.
Honourable Second Member for Vieux Grand-Port and Rosebel.
Thank you, Mr. Deputy Speaker. Sir, it's question B 223, please.
Mr. Deputy Speaker, sir, the Flak Maibo B28 road is a classified road that links several coastal villages such as Vieux Grand-Port, Bois des Amourettes, Bambou-Verrier, Quatre-Sœurs, and Deux Frères. I am informed by the Central Water Authority that with a view to providing adequate water supply to the inhabitants of these coastal villages, it has embarked on a project for the renewal of the pipelines along the B28 road with the objective of addressing the long-standing issues of low water pressure, water leakages, and pipe bursts due to aging infrastructure. The pipeline renewal project is being undertaken in two phases, namely Phase 1 from Anse-Joncé to Bambou-Verrier to Petit-Sable, covering a distance of 6.4 kilometers, and Phase 2 from Féané to Anse-Joncé, covering a distance of 6.7 kilometers. Mr. Deputy Speaker, sir, in line with the provisions of the Road Act, the CWA made application for wayleaves to the RDA for implementing the pipeline works. Wayleave for Phase 1 was granted on two occasions, namely on 19 June and 18 July 2024, for the stretch from Anse-Joncé to Bambou-Verrier to Petit-Sable. For Phase 2, wayleave was granted on 26 September 2024 from Féané to Anse-Joncé. The wayleaves were subject to strict compliance with the RDA wayleave conditions for laying of pipes, ducts, and cables. In fact, the CWA and its contractors have to ensure that works are executed with minimum disruption and inconvenience to road users. In addition, any damage caused to the road infrastructure shall be made good at their own cost. These conditions include, inter alia, the following. First, temporary reinstatement of all trenches along the classified roads using crusher run and a 30mm layer of asphaltic concrete as per specifications. Second, after completion of the permanent works for the stretch from Féané to Bambou-Verrier, half widths of the existing road should be milled and resurfaced, and from Bambou-Verrier to Petit-Sable, the whole width of the existing road should be milled and resurfaced. And thirdly, the works should be properly delineated with appropriate fluorescent bends. Mr. Deputy Speaker, sir, despite these measures, the RDA has raised concerns regarding the poor conditions of the temporary trench reinstatement along the B28 road. Several inspections have revealed that the reinstatement works were not up to the standard of the RDA, wherein the presence of a dangerous pits, crusher run having washed away or exposed to traffic were observed, therefore representing a serious threat to the safety of road users as well as the public at large. Accordingly, the RDA has issued several notices to the CWA, a recent one on 18 March 2025, requesting it to take immediate remedial action. Failure to comply with these conditions may result in the forfeiture of the 20 million rupees bank guarantee provided by the CWA for these works. As regards the villages of Quatre-Sœurs and Deux Frères, no request for wayleave was received by the RDA for pipeline renewal works. I am informed that the existing water pipeline, which is an old one, is subject to recurrent bursts and leakages, resulting in the asphaltic wearing course thereat to be damaged. The RDA has consequently requested the CWA to consider permanent pipe laying works at the earliest. Mr. Deputy Speaker, sir, I am further informed by the CWA that all works, including road reinstatement for the Phase 1 project, will be completed in this financial year, and those for Phase 2 will be completed in the next financial year. Additionally, a separate contract is currently being prepared by the CWA to appoint a Grade A contractor for the permanent road reinstatement from Ferney to Petit Sam. Same is expected to be launched under the open national bidding by April 2025.
The second member, Honorable Second Member for Flac and Bonacay.
Monsieur le Président, B224, s'il vous plaît.
Mr. Deputy Speaker, the Trust Fund for Excellence in Sports was set up under the Finance and Audit Trust Fund for Excellence in Sports, Regulation 2002. Its mission is to design, finance and implement projects and schemes for the benefit of, first, sportsmen and sportswomen who have achieved excellence in their respective field at national and international level, young athletes who have achieved excellence in their respective field at school level, and retired sportsmen and sportswomen who need support and financial assistance in order to embark on other professional activities. Mr. Deputy Speaker, I am informed by the Trust Fund for Excellence in Sports that in pursuit of the aforementioned mission, it has established a program to support student athletes who are pursuing tertiary vocational studies locally and abroad. In this context, the Trust Fund has supported over the last 5 calendar years, that is from the year 2020 to the year 2025, 71 athletes at the sum of 13,263,716 rupees and 40 cents has been disbursed.
Yes.
Speaker, it takes 8 long years for a junior student, 8 long years of sweat and blood to become a professional athlete. Will the Honourable Minister confirm whether the amount disbursed has been slashed by almost 50% for all those athletes pursuing tertiary level studies?
Mr. Deputy Speaker, I have been aware that the quantum allocated to the athlete pursuing tertiary education has been reviewed by the previous board from 260,000 to up to 2,000 per academic year based on a revised set of performance-based criteria. The newly constituted board of the Trust Fund will assess the existing scheme holistically and will come up with a proposal in due course.
Monsieur le Vice-président, si je comprends bien la dernière réponse de la ministre, un nouveau board vient d'être constitué et peut-on savoir qui c'est qui est à la tête de ce board?
We'll read the list of the older members in the table of the Assembly.
The Honourable Second Member for Rodrigues.
Yes, thank you. B225.
Mr. Deputy Speaker, sir, in regard to Part A of the question, I am informed by the National Heritage Fund, a parastatal body operating under the aegis of my ministry, that there is currently no national policy in place specifically dedicated to the protection of national heritage sites from natural disasters and the impacts of climate change. This is a serious concern, especially as Mauritius, being a small island developing state, is increasingly exposed to extreme climate-related hazards such as cyclones, torrential rainfall, rising sea levels, flooding, and coastal erosion, all of which pose significant risk to our cultural heritage. Mr. Deputy Speaker, sir, while no national policy was developed or implemented by the previous government to address this challenge in a comprehensive and coordinated manner, some isolated efforts were made in response to obligations under the World Heritage Convention. As such, I am informed that there is a disaster risk management plan for the Apravasi Ghat World Heritage property, and there is a draft plan which is under preparation for Le Monde cultural landscape. These were initiated as part of UNESCO World Heritage Sites requirements. However, for the vast majority of national heritage sites across the country, no disaster preparedness or climate adaptation measures have been systematically adopted, nor has the legislation been updated to reflect these urgent needs. Mr. Deputy Speaker, sir, this government has placed this pressing concern high on its agenda, recognizing that the conservation and safeguarding of our national heritage must go hand in hand with disaster and climate resilience. This priority is clearly reflected in the government program 2025-2029, a bridge to the future, which pledges to strengthen cultural, the protection and valorization of heritage sites. Accordingly, the National Heritage Fund Act 2003, which is now outdated, will be reviewed. A new National Heritage Authority Bill will be drafted to include, inter alia, emergency preparedness plans, integration of climate change adaptation into conservation planning, and use of modern tools such as artificial intelligence and 3D scanning to document, monitor, and protect heritage assets. Mr. Deputy Speaker, sir, in regard to Part B of the question, I am informed by the National Heritage Fund that it did not receive any request from the Chief Commissioner's Office of the Rodrigues Regional Assembly for the renovation or demolition works of the residency building in Port-Maturin, Rodrigues. However, during a visit in Rodrigues carried out by two officers of the National Heritage Fund on 18th March 2025, at the request of the Rodrigues Tourism Office, the two officers were informed that a tender had already been awarded for the repair and restoration of the residency building. Thereafter, the two officers were called upon to attend a meeting with the departmental head of the commission, whereby more details of the renovation project were communicated to them. Since the building is a national heritage since 2001, the departmental head was informed that prior to any repair or restoration works, the clearance of the National Heritage Fund should have been sought as stipulated under Section 13(3) of the National Heritage Fund Act 2003. I am further informed, Mr. Deputy Speaker, sir, that the National Heritage Fund has on 20th March 2025 instructed the Island Chief Executive to stop all works thereat with immediate effect and to submit a detailed clarification on the matter to enable the Technical Committee of the National Heritage Fund to examine same and thereafter make appropriate recommendations to the National Heritage Fund Board. Thank you.
Yes. Thank you, Honourable Minister, for his answer. May I ask the Honourable Minister whether the NHF Board will consider the identification of additional sites or monuments deserving to be designated to the status of historical and cultural heritage site in Rodrigues, just to name a few, such as St. Gabriel Cathedral, Maurice Telecom Building at Mont Venice, and also the lost recoverable terraces remain at Nosami?
Yes, of course, we'll do it.
Yes. One last question.
No, I have to. Just if you allow me, Mr. Speaker, very important. With regards to, as per Schedule Section 2 of the Act, NH National Heritage of Mauritius, Territorial Rodrigues, out of a list of 6 sites, there is only one private property, namely Ben Gontran House at Barclay Street, Port-Maturin. May I seize this opportunity to humbly ask the Honourable Minister to request the National Heritage Fund Board to discuss with a private owner for necessary measures and support as may be necessary to maintain and protect this house so that it does not lose its national heritage identity and value. Thank you.
Yes, Honourable Member, I will ask the National Heritage Fund to do so. Thank you.
Yes. The Honourable Second Member for Grave, Cotonou. Question has been withdrawn at the site? Yeah, withdrawn. Okay. The first member for Montaille-Blanche and Grande Rivière, Southeast.
Mr. Deputy Speaker, sir, B 227.
Mr. Deputy Speaker, I'm informed that Belair Rivière Sèche State Secondary School was constructed some 15 years ago. I wish to inform the House that the riverside of the school is secured with 1.8 meters chain link fencing. This was meant to be a deterrent and have access to the river. However, I have to admit that the fencing does not prohibit intruders from entering the school. I'm also informed, whilst the fencing is still in good condition, yet it might not have been placed at the right place. Mr. Deputy Speaker, with a view of enhancing security at the school, I have instructed that the possibility of having another fence be explored along the alignment of the existing retaining wall over a stretch of some 120 meters, further upwards, which would be a more suitable deterrent to intruders. This new proposed structure would go a long way towards ensuring the safety and security of our students. Mr. Deputy Speaker, I wish to inform the House that, subject to technical feasibility and availability of funds, this work can be completed in a short span of time, approximately 4 weeks, as from the date of start of works.
The Honourable First Member for La Caverne, Felix.
Mr. Deputy Speaker, B228, please.
Mr. Deputy Speaker, sir, I am informed that the Phase 3 of the Metro Express project, which pertains to the extension of the metro line over a distance of 3.4 kilometers from Rose Hill to Redry, was implemented following a decision taken by the then government on 30th December 2020. I would like here, Mr. Deputy Speaker, sir, to remind the House that at that time, according to records available at my ministry, the light rail project was being spearheaded by the then Prime Minister's office. Mr. Deputy Speaker, sir, with regards to Part A of the question, I am informed by Metro Express Limited that a proper feasibility study, that is, a proper technical and financial study, was not carried out for Phase 3 of the Metro Express project. In fact, the decision to proceed with the project was made following a case put forward by the consultant for the project, Singapore Corporation Enterprise, in 2016, in its reference design. The consultant had identified the regions of Eben, including the Cyber City and Redry, as a critical commuter base, which justified the need for an efficient mass transit. The then management of MEL, Metro Express Limited, estimated the number of commuters to be 30,000 at Eben and 11,000 at Redry. Mr. Deputy Speaker, sir, I am informed by MEL that this line has much lower commute figures, averaging daily 3,200 commuters on weekdays, 1,490 for Saturdays, and 522 for Sundays. The total fare amount generated for year 2024 is 30 million rupees, 736,428, resulting an average monthly amount of 2,561,369 rupees. Worse, if we take the fare amount for last month, February 2025, it's only 1.7 million rupees. That is much less than the expected ridership income. It is therefore evident, Mr. Deputy Speaker, sir, that MEL is operating at a terrible loss over the line. Mr. Deputy Speaker, sir, during the previous mandate, I had on 2 occasions, personally myself, drawn the attention of the House and the population at large, firstly, in the much debated parliamentary question B223 of 18 April 2023, and the next one, 1 month later, PQB 596, that the project was not workable. In fact, I had used the word total failure. It's in Hansard. When we take into account that the cost of phase 3 stood at 4.455 billion rupees, which is the figure the Honourable Lobin had requested for in Part B of the question, a simple calculation shows that this tantamount to 1.3 billion rupees per kilometre without any cost of trade. That is 1,3 million de roupies, 1,34 millions de roupies par mètre linéaire de voie ferrée. This much, 1 meter. This costed 1.34 million rupees on average, from Rose Hill to Redri. It costed quite a lot. Mr. Deputy Speaker, sir, these 4.55 billion rupees worth of works were effected through a variation to the existing main contract for Metro Express project with Larsen and Toubro. This amounts, coincidentally, to 24%, slightly less than the prescribed threshold of 25% of the equivalent of 18.8 billion rupees for the main contract. Mr. Deputy Speaker, sir, as a professional of the construction industry, I've always viewed this particular course of action adopted by the then government for this particular variation as being highly debatable, because the extension per se was not along the line QPIP to Port Louis, but was in a completely distinct new line from Rose Hill to Redri, which is not in the direction of the main metro line, which costed 18.8 billion rupees. Mr. Deputy Speaker, sir, with regard to further extension of the metro line, I'm informed that a feasibility study was carried out in October 2021 by a team of Metro Express Limited with the technical assistance of Rights Limited. This study covered the extensions of the metro line from Redri towards Côte d'Or and Saint-Pierre, and from QPIP to La Vigie. The report was submitted in April 2022 at a total cost of 21.98 million rupees, nearly 22 million rupees, out of which 18 million was paid to Rights and 3.98 million rupees to the in-house team at Metro Express Limited. No tender exercise was done for this consultancy exercise. Mr. Deputy Speaker, sir, I wish to point out that on the procurement process for the construction of under Phase 4 of the Metro Express project was cancelled by the Empowered Interministerial Committee of the Government of India in September 2023, and that the project is currently put on hold as advised by the Exim Bank of India. Thank you.
Yes.
May I ask the Honourable Minister, with regard to this total failure of the Metro Express project, will his ministry conduct a comprehensive and full-fledged study with regards to the impact now on the coffers of the state with regards to further money that this government will now have to pour in to make this workable, in view of this total failure of Metro Express that have been implemented?
Certainly. We are implementing measures. As a matter of fact, I've given instruction to stop the train working on Sundays, because it's a total wastage. As regards the other days, we will be working on it and to try and see how to enhance ridership on that line.
The Honourable Third Member for Portrush South, Portrush Central.
B229, please.
Mr. Deputy Speaker, sir, first of all, let me thank the Honourable Member for this question, and also let me take this opportunity to congratulate the Honourable Member for his National Day Award 2025 as Grand Officer of the Order of the Star and Key of the Generation for his contribution in the medical and social fields. Mr. Deputy Speaker, sir, I wish to inform the House that persons suffering from a disability are entitled to an invalid basic pension or a disability or a disability allowance and/or a carer's allowance after an assessment by a medical board. Under the prevailing system established prior to the present government, a medical assessment is carried out by medical practitioners of my ministry to determine the eligibility to the invalid's basic pension or disability allowance or carer's allowance. Assessments are carried out either by a medical board, which comprises of 2 medical practitioners, or by 1 medical practitioner at the claimant's residence for those whose mobility is limited and who cannot attend the medical board. As per law, the entitlement for the invalid's pension is based upon the claimant being at least 60% incapacitated for a period of at least 12 months. The law as such does not make any provision for the duration of any of the pensions. A medical guideline, last updated in 2016, in collaboration with the Ministry of Health and Wellness, is used by medical practitioners who sit on medical boards for assessment of claimants for the benefits. This guidelines also provides for the duration of the award of the disability benefits. Statistics recently compiled by my ministry reveal that under the present system, 1 in 2 cases where pension benefits are approved, they are for a period of 1 year. In 32% of cases, pensions are awarded for 2 years. This means that every year, more than 50% of invalidity pensions or benefits claim being assessed relate to renewal cases. That is cases where pension has lapsed and thus need to be reassessed for renewal. This is one of the reasons why many Mauritians are dissatisfied with the present system. Mr. Deputy Speaker, sir, to reply to Part A of the question on how many cases have been cancelled for the last 4 years, please allow me to make some clarifications. Disability-related pensions and benefits can be stopped for 2 reasons. First, they can be suspended in departure cases or in cases of free consecutive non-encashment of pension, or where doubtful documents were produced by applicants or malpractices have been reported by whistleblowers. Second, pension and benefits are discontinued after the duration period of the pension has lapsed, and same has not been renewed by the medical board. With regard to Part A of the question, I'm informed that for the period July 2021 up to 20th March 2025, there were 335 suspended cases of BIP, basic invalid pension, disability allowance, and carer's allowance. Additionally, 16,134 cases of BIP, disability allowance, and carer's allowance have been discontinued. for the period of July 2021 up to 20 March 2025 after reassessment by the medical boards. Moreover, 29,013 cases of BIP, disability allowance, and carers allowance have been disallowed, that is, not granted, by the medical boards for the same periods. It should be pointed out that for the same period, my ministry has received 33,360 applications for basic invalid pensions, 1,179 applications for disability allowance, and 42,915 applications for carers allowance. For the benefit of the House and the public, I am tabling indicative statistics on what I have been just mentioned. With regard to part B of the question, I wish to inform the House that under the present legislation, a person whose case has been disallowed or discontinued or only provided a statement that the claimant has not satisfied the 60% incapacitated criteria. The onus to prove the contrary is put on the claimant, who has the right to make an appeal to the medical appeal tribunal within a period of 1 month from the date of disallowance notice. In case claimants do not appeal, they may make a fresh application to the medical board for the benefit after 6 months. An earlier application can be made in the event that there is an aggravation of the medical condition of the person supported by a medical certificate. As for measures envisaged by my ministry, I need to highlight that the current system is based on medical guidelines, and the assessment system is based on medical guidelines and the 6th schedule of the National Pensions Act. Thus, a broad-based reform is being explored to include the functionality of a potentially disabled person. That is, can the person work? Can the person feed himself or herself? Can the person use public transport? Can the person take care of himself? Just to mention a few examples. In addition, my ministry is also exploring the reform of the entire operation of medical board. Shall the board have access to the entire medical file of the claimant and perform its operations within public hospitals and centers, as is presently the case for the claims based on eye vision disability? Shall the doctors serving on medical boards and carrying domiciliary visits continue to be employed on a sessional contract basis? Or shall they be the backbone of a new system? Proposals are being considered to include representatives of organizations representing people with disabilities within the medical board and appeal tribunal dealing with disabilities benefit entitlements. Furthermore, the very criteria of 60% incapacity is being questioned. The possibility of introducing a graduated benefit system based on the percentage of incapacity and functionality is being explored. We are studying different systems from different countries in this respect. In the long run, the introduction and the talking of e-health system with the e-social security system will greatly facilitate the efficiency and modernization process once we settle the core issues on the coming reform. To conclude, Mr. Deputy Speaker, sir, my ministry, with the support of the government, is moving towards a significant change of the system to ensure a dignified, right-based, and efficient disability pension benefit system in Mauritius. In this context, to promote inclusiveness my ministry has opened as from 18th March until the 10th April 2025 a last round of input from citizens and associations defending people with disabilities to formulate proposals for changes in disability pensions and benefit system, as well as amendments they deem appropriate to the not yet proclaimed the protection and promotion of the rights of persons with disabilities Act 2024. Thank you, Mr. Deputy Speaker.
Thank you for your long and comprehensive answer. No additional. You have a supplementary? One last supplementary, because the answer was quite comprehensive.
Yes. Thank you, and thank you for the compliment at the beginning of your answer. May I ask the Honourable Minister, based on the medical assessment that we have at the present by medical practitioners and the medical board, whether he would also consider the implementation of a Barema system, the Barema system which is being used widely in Europe, and I have copies of them from different countries which I'll hand over to you afterwards, that can encompass the medical, functional needs, assistance needs, and above all, the additional costs incurred by relatives. I'm just hoping that this can be implemented. And my next, there's a small question. This is a very sensitive issue. It's on the radio every day. Very sensitive. I would like to ask the Honourable Minister that there should be in the department an emergency appeal system, rather than the normal appeal, an emergency appeal system with regards to certain individuals who have been invalid since birth, whose conditions have not changed, but have all been denied of the invalidity pension, namely of one case that may make history for him, of a young boy born epileptic, cerebral palsy, one arm longer than the other, one leg shorter than the other, who cannot talk, and yet his pension has been denied. I will share the documents with you. Please look at how these individuals who are bona fide invalid people can have an emergency system for your ministry so that they can have the funds to have a better living. Thank you.
We are on the same wavelengths. Since I took this office, we share the same concern and we are studying in the same direction. All these suggestions and the documents that you will submit will be considered. Thank you, Honourable Member.
The Honourable First Member for Savannah and Black River.
Mr. Deputy Speaker, sir, the Plaine Champagne B103 road starts at Limar and ends at Chamarel village and is approximately 13 kilometers long. Several significant signs of distress and road edge failures were noted along a stretch of 1 kilometer of the B103 road, specifically between Chamarel-Romery and Varennes-sur-Maune, which required rehabilitation and grading along that segment. A project for the upgrading of the road and slope stabilization works was accordingly implemented by the Road Development Authority. Works have been substantially completed and the road reopened to the public on 20 February 2025. I am informed by the RDA that while major construction works have been completed, there are some minor works and monitoring activities which are still ongoing. As regards road safety survey, I am informed by the Traffic Management and Road Safety Unit, TMRSU, that a road safety audit is usually conducted in the context of the construction of a new road to see whether road safety may be improved on the road prior to its opening. The TMRSU has further informed that in the case of the B103 road, the works comprise slope stabilization along a small stretch of the existing road, and accordingly, a road safety audit was not required. However, a site visit was carried out by the TMRSU and several road safety improvement measures have been recommended, namely placing of handrails and guardrails, which I'm informed have already been implemented. In addition, as part of the project, the RDA has submitted road marking, traffic signage, and other road furniture details to the TMRSU for approval prior to implementation. Given that the road is still being monitored jointly by the TMRSU and the RDA, a site meeting will be held by both parties by the end of March 2025 to identify additional safety measures to be implemented if required. Mr. Deputy Speaker, sir, as regards Part B of the question, it should be highlighted that the road is heavily bounded by trees and vegetation. Prior to the opening of the road, the contractor on the project had carried out a first cleaning and trimming of trees within the 1 kilometer segment of the road where the works were ongoing. The cleaning and trimming of trees along that stretch are still ongoing and will be completed by the end of this month. Only last Monday, during the management meeting at the level of the RDA, I highlighted that I was not satisfied with the lopping of branches along B103 road and requested the RDA to take urgent remedial actions. The RDA has accordingly committed to complete the cleaning and trimming of trees along the remaining section of B103 road very soon. Subsequently, this will form part of the ongoing routine maintenance program by the RDA's maintenance section.
Yes, sorry, I will call B230 now. Honourable Third Member for Portage South.
B230, please.
Mr. Deputy Speaker, as regards to Part A of the question, I have been informed that the Immaculée Conception School is no longer being used for educational purposes since 2012, given its state. I'm also informed that the premises where the school was formerly housed were officially handed over to the Mauritius Police Force in April 2017 for the setting up of a police warehouse. Following complaints received on the Citizen Support Unit portal in 2021 by inhabitants of the region, my ministry took note that the Mauritius Police Force did not go ahead with the said project. Moreover, the Ministry of Housing and Lands has informed my ministry on 12 October 2021 that the premises are under its control but were being occupied by the Field Services Unit, a department falling under the aegis of the Ministry of Local Government. Therefore, this school no longer falls under the purview of Ministry of Education and Human Resources since April 2017. Mr. Deputy Speaker, as regards to Part B of the question, my answer is yes. We are conscious about the insecurity there. Complaints from the public were made to my ministry in 2021 pertaining to drug addicts and dangerous squatters occupying the premises. The Ministry of Housing and Lands was accordingly requested to undertake necessary and appropriate actions, given that the land on which stands the ex-Immaculée Conception School is under the control of the latter ministry. Additionally, the Mauritius Police Force was requested to reinforce police patrol around the premises of the school and take necessary actions against the illegal occupants for the safety and security of the public. This request was reiterated this year again. Thank you.
The Honourable First Member for Portage North and Mont Island.
Thank you, sir. B232.
Mr. Deputy Speaker, sir, the House is aware that I have been replying to several parliamentary questions recently about the pool level of bus transport service island-wide, and I believe this is also the case for regions which the Honourable Member has referred to a question today. In fact, the House will recall that I have also made several public announcements in and outside the House, stressing on the prevailing malaise in the bus industry. I seize this opportunity to reassure the House and the travelling public at large that the improvement of the level of public bus transport is one of my priorities. We, at the level of my ministry, are fully committed to look for workable solutions with a view to improving the services around the island in line with the numerous measures which I have already enumerated in the House during my previous replies. Now, coming to the region of Vallée des Prêtres, Chitrakoot and Caroline, Mr. Deputy Speaker, sir, I am informed by the National Land Transport Authority that the public transportation services in these localities are exclusively offered by the United Bus Service through the following routes. Route 41, Vallée des Prêtres, the new transportation center. Route 41A, Upper Vallée des Prêtres. Route 160, Vallée des Prêtres, new transportation center again. Route 160A, Upper Vallée des Prêtres, Cité Valégie. And Route 237, Vallée des Prêtres, Mont-Selman-Rafré-Paille. I am further informed that 13 road service licenses have been granted to the United Bus Service to operate its buses along the aforesaid routes. In accordance with the established timetable, buses along Route 41, 41A, 160 and 160A should operate at 30 minutes interval during peak hours and on an hourly basis during off-peak periods. As regards to Route 237, buses are required to ply at an hourly interval throughout the day. The hours of operation along these routes are 5 o'clock in the morning and 5:25 to 8 o'clock at night. Mr. Deputy Speaker, sir, I wish to also point out that inspections conducted by the NLTA and Inspectorate have revealed that the UBS buses plying in the regions which I have just mentioned are not adhering to the prescribed timetable, and this has undeniably resulted in complaints from commuters thereat in respect of service, delays and inconsistencies. The NLTA Inspectorate has in fact pointed out that the UBS is operating at a lower number of buses out of its operational fleet, and this situation has been observed across all its route island-wide. It's a malaise actually right now. Despite their being availed of free transportation service. To this effect, I've been informed that the NLTA has had dedicated meeting with the traffic manager of the UBS on 30th August 2024, whereby the latter was apprised of the issues and complaints. The representative of the UBS undertook to take remedial actions, highlighting the main cause thereof related to the shortage of drivers, and that necessary arrangements were underway for the recruitment of foreign labour. The representative of the UBS was once again convened at the NLTA last month, that is in February 2025, in view of the persistent situation. It would seem there has been no improvement so far. Mr. Deputy Speaker, sir, I would like to inform the House that I can humbly state that after 4 months in office, that I've been able to understand the problems being encountered by the travelling public and the reasons thereof, which are multi-pronged. Let me give you 3 reasons. Firstly, I'm inclined to strongly believe that the issue of recruitment of foreign workers have become some sort of a pretext for several bus operators to keep their buses in their garage while benefiting at the same time from government subsidies monthly. This is across the board and across all companies. Unfortunately, it is a malaise right now. But secondly, I've been made aware that various representations I have received from several bus operators. They do not treat their employees properly, and hence potential candidates are reluctant to join these companies. Thirdly, and they don't realize that importing foreign labor can be more expensive. Thirdly, in some cases, bus operators have resorted to employing drivers and conductors who are not fit and proper for the job. And this has led to the alarming and dangerous situation whereby we are having cases of bus crew operating under the influence of alcohol and drugs. I've had extensive meetings with the Mauritius Police Force during the course of last week and even before that to try and address this situation. The recent accident which occurred at Solitude, whereby a school bus was being driven by a conductor who was not only under the influence of illicit drugs, but was not even the holder of a valid driving license, is telling of the situation we are in right now. Mr. Deputy Speaker, sir, let me reassure the House that the introduction of the fleet management system, a project on which my ministry is actively working on, will be a game changer for the bus industry, and that will certainly redress the issue of inadequate buses and non-adherence to established timetable. The request for proposal is currently being worked out by the consultant, and hopefully the project will be in place by the end of this year. Nevertheless, in the meantime, based on the recommendations of the NLTA regarding the timetable, plausible remedial actions, or the immediate plausible remedial actions, I've asked the latter to consider, the NLTA, the possibility of licensing additional RSLs according to Section 77 of the Road Traffic Act 2023, which empowers me to do so, to other bus operators in order to improve the level of service in the regions where inhabitants are encountering acute transport problems, including the regions mentioned in the question of the Honourable Member, and I'm waiting for a reply from the NLTA. Thank you.
Yes, one question.
Thank you, Mr. Speaker, sir. Bus transport is a real headache in the regions that I've mentioned in my PQ, Vallée des Prêtres, Chitrakout and Caroline. Monsieur le député Speaker, il est déplorable de constater que certains autobus de la United Bus Service sont âgés de plus de 15 ans, lesquels sont bons pour de la vieille ferraille, sont toujours en circulation dans la circonscription, à l'instant dans les régions citées à l'instant. Donc ma question, alors, est-ce que le ministre compte ouvrir des lignes à d'autres compagnies d'autobus? Clearly, there's no will from the side of the actual bus operators to improve their services there. Can the Honourable Minister ask the Inspector of the NLTA to be more active there until the situation improves? Thank you.
Can you repeat what you have just said, the last phrase?
The end of a lifetime of a bus is 20 years old, legally. So 50 years is 5 more years to go, but that is not a reason why the bus should not be in good condition. So I will look into the issue for the specific buses plying that route, and we'll come back to the member for due course.
The Honourable Second Member for Mayberg and Glenmany.
234.
Okay. Mr. Deputy Speaker, sir, I am informed by the National Land Transport Authority that prior to the amendment which was brought to Section 77 of the Road Traffic Act in 2023, no temporary road service licenses were granted. However, I am informed that during the period 24 October 2023 to 16 September 2024, 45 road service licenses, temporary road service licenses, have been granted for the operation of buses, that is 42 in Mauritius and 3 in Rodrigues. And the Rodrigues ones are under judicial review right now, following application made by the Rodrigues National Assembly, Regional Assembly. I would wish to point out that according to information provided to me, approval was obtained from the then Minister of Land Transport and Light Rail for 13 other road service licenses on 1st October 2024, but these licenses were not issued by the NLTA as the general elections were imminent. That was 4 days before the Parliament was dissolved. These RSL have been granted under the provisions of Section 77D of the Road Traffic Act, which were introduced in 2023 under the Road Traffic Amendment Act number 10, which came into operation on 17 July 2023. This section of the law, in fact, empowers the Minister to either, 1, direct the NLTA to allow an existing licensee to redeploy his bus from an existing route to another, or, number 2, direct the NLTA to grant a new road service license to an existing licensee to operate services along a route designated by the minister. In both instances, the minister has to ascertain that the redeployment of any bus or the grant of a new license is in the public interest based on a report from the NLTA to the effect that the redeployment or grant of license is justified and that there is a need to supplement the service along any designated route. The minister, while directing the NLTA, has also to specify the duration for which the license is to be granted. Mr. Deputy Speaker, sir, according to the NLTA, all 45 new licenses have been granted following applications submitted by existing licensees to the then minister for specific routes. The NLTA then submitted a report on the need for supplementing bus services along the route applied for. The then minister subsequently directed the NLTA to issue the license. Another pertinent observation was in respect of the grant of these temporary licenses is that the law clearly stipulates that where the minister is satisfied that a particular route or area is inadequately served and that in the public interest to improve bus service on that route or area, he may direct the NLTA to grant a road service license for such duration he may deem fit. The word duration is listed there. To an existing licensee so as to allow him to operate bus services on such route or area designated by the minister. End of quotation. However, it is worth pointing out that although it is the prerogative of the minister in law to determine the duration for which the license is to be granted, such was not the case I'm given to understand. It would seem, therefore, that the NLTA has taken it upon itself to decide on the temporary licenses to be for an initial period of 3 months. I'm also being made aware that these temporary licenses have been subsequently been renewed for additional periods of 3 months administratively, solely at the level of the regulator, which is the NLTA. I've also been informed that in the case of the 45 new licenses issued, officers of my ministry were not at all involved in the whole licensing processes. Sealed confidential files moved to and fro between the NLTA and the office of the then minister. The ministry did not have the slightest hint of the rules where licenses were being granted, the manner in which the existing licensees were becoming aware that they should submit applications to the minister for any specific route, and of the mechanism as to how the NLTA was requested to submit report on the level of service. Nothing could be found in any file in my ministry, I am told. I am further informed that the whole licensing exercise seems to have been carried out in strict confidentiality, both at the level of the then minister's office and the NLTA. As a matter of fact, there have been several representations from operators as to the manner in which these temporary road service licenses have been granted, and I'm inclined to think that these may have prompted the Honourable Apollo to come up with this question. The Honourable Member may rest assured that since I took office at the Ministry, I have stressed that henceforth all legal and administratively established processes should be strictly adhered to. Mr. Deputy Speaker, sir, as regards Part B of the question, I am informed that the established administrative procedures have not been duly followed, and it would appear that, number one, the then minister was approving the applications for temporary road service licenses without referring these files through proper channel, that is the administration, resulting that in fact there is no record regarding these applications and the grant thereof at my ministry. I am informed by the NLTA that the officer in charge of the NLTA took it upon himself to grant these temporary road service licenses for an initial period of 3 months, despite the fact that such duration should have been specified by the minister as provided under the law. In the light of the above, I wish to reassure the honourable member and the public that I have already given instruction for an inquiry to be conducted properly, as per the request of the Honourable Apollo in his main question for an inquiry. In the event any malpractice is confirmed in the manner these temporary licenses have been granted and or renewed, necessary actions as may deem necessary will be initiated accordingly. Additionally, an assessment will be undertaken as to whether these temporary licenses are still required. In the affirmative, the NLTA will be requested to open up application for permanent road service licenses to be granted along the relevant routes for the benefit of the travelling public. Finally, I wish to enlighten the House that the buses licensed with a temporary road service licenses are benefiting from free travel compensation monthly. Thank you.
Mr. Deputy Speaker, thank you, the Honourable Minister. According to your answer, I think a full-fledged inquiry should urgently take place. Can the Honourable Minister table the list of those who have been granted these licenses and also the list who have not been granted? And can the Minister confirm to the House who signed all these documents?
Yes. I will table all the requested information from the Honourable Member. For those who were issued a license, for those who were made application, but which were not issued a license because elections were imminent, and I think the signature of the Honourable Minister Ganu is there. So,
the Honourable second member for Belrose and Cadbourne.
B 235, merci.
Mr. Deputy Speaker, sir, I am informed that the junction of Victoria Avenue, Sir Guy Forget Avenue, and Avenue Belrose is a signalized cross junction found along the Metro Express corridor. The signalized cross junction falls under the traffic signal priority system, which is managed by the Metro Express Limited. The signalized cross junction caters traffic movement in 8 directions, so quite busy, as well as for train movement. The traffic signal sequences were configured thereat following a traffic survey carried out in 2018 based on the train movement and traffic volume and traffic flow. Mr. Deputy Speaker, sir, with the present configuration, the train has priority signal at this junction, as is the case at all Metro Road junctions. Additionally, traffic along Sir Guy Forget, which is a one-way street towards Belrose Avenue, is provided more green time in the morning peak due to higher volume of traffic. Similarly, additional green time has been allocated for traffic coming from Victoria Avenue in the direction of Catbourne in the morning and vice versa in the afternoon, based on the traffic survey of 2018. Mr. Deputy Speaker, sir, almost 6 years have passed since the traffic light thereat has been configured, and traffic patterns may have evolved during these years. The Metro Express Limited has already been requested to carry out a fresh survey in collaboration with the Traffic Management and Road Safety Unit of my ministry to that effect, and with a view to adapting the configuration of the traffic light based on the findings. The exercise is expected to be completed in 1 month's time. I have therefore to thank the Honourable Member for coming up with this question, as it has given technicians of my ministry the opportunity to question the relevance of the 6-year-old configuration.
Yes, one question.
Je vous remercie, Monsieur le Vice-président. En effet, nous avons reçu, le docteur Boulel, vous-même et moi, de nombreuses plaintes des usagers de la route concernant les embouteillages au carrefour de l'avenue Victoria et de l'avenue de Belrose à Catbourne. Will the Minister inform the House if his ministry will envisage to introduce smart traffic light system, communément appelé en français des feux de signalisation intelligents, that adjust based on real-time traffic conditions to enhance efficiency? Thank you, Mr. Deputy Speaker.
Yes, I thank the Honourable Member for this question. We are actually working in that direction. There is a consultancy exercise that my ministry is conducting now, and it is called Adaptive Traffic Control System, which have as qualities, I must say. It is being smart because it uses artificial intelligence to monitor traffic, and it will henceforth, if going forward, prevent long waiting time when there are no cars, for example. So, and also red light cameras. If someone brûle feu rouge, par exemple, it can spot. So we are working in that direction.
Okay, one last question we'll take for this session. B236. Honorable Second Member Robin-Rose.
Je vous remercie, Monsieur le Vice-président. B236.
Mr. Deputy Speaker, sir, I am informed that the report of the fact-finding committee set up to shed light on the circumstances that led to baby S being admitted to the neonatal intensive care unit NICU of the Sir Sivasagar Ramgoolam National Hospital on 21st October 2022 was handed over to the then Minister of Gender Equality and Family Welfare on 22nd November 2022. Mr. Deputy Speaker, sir, I'm further informed that the committee was mandated to carry out an in-depth inquiry and to submit its report on the basis of the terms of reference as follows. A. Investigate into the circumstances leading to the baby being admitted to the NICU. B. Investigate on the management of and services being provided to the baby. C. Investigate on the management of the residential care institutions, shelters for children falling under the purview of the National Children's Council in general. And D. Make recommendations for 1. Addressing shortcomings identified. 2. Reforms to be brought with regard to the procedures for the placement of minors in residential institutions/shelters for children. And 3. The management of residential institutions/shelters for children. Mr. Deputy Speaker, sir, I wish to inform the House that the report of the fact-finding committee is being presently examined and consideration will be given to the recommendations or even the report itself being released in due course.
Just one last question.
Je vous remercie, Monsieur le Vice-président. Would the Minister inform the House what measures have been implemented so far based on the recommendation of the fact-finding committee? Thank you.
As I informed the House, the report is still being under consideration and further actions will be taken in due course.
Thank you. Honourable members, the table has been advised that the following PQs have been withdrawn. B243, B247, B259, B260, B264, B265, B262, B257, B263, B254, B256, B246, B249, B251, B237, B252, B258, B266, B238, B245, B250, B255, B240, sorry, B242, and B248. Time is over. The Honourable Madam Speaker will take the chair.
Thank you, Deputy Speaker.
Motion.
Yes, Honourable Prime Minister.
Madam Speaker, I'd like to move that all the business on today's order paper be exempted for the provisions of paragraph 2 of Standing Order 10.
Yes. The question is that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10. Those in favour say aye. Those against say no. The ayes have it.
Statement by Ministers. None. Public bills, first reading.
Madam Speaker, I move that the Public Inquiries Bill number 5 of 2025 be read a first time.
Yes, the motion needs to be seconded. Thank you, Deputy Prime Minister.
Public bills, second reading.
Speaker, I move that the Bail Amendment Bill number 3 of 2025 be read a second time.
Yes.
Madam Speaker, the term bail is a common term that is frequently used in our legal jargon, and I presume in other jurisdictions also. However, the term bail remains an undefined term in our law books. It is not even defined under the Bail Act of 1999, which is the main legislation that deals with bail. Even in the Constitution, the term bail is not defined, nor is the term bail used, other than under Section 53A, which has anyway been declared unconstitutional. However, Madam Speaker, the alternative term used in the supreme law of this country is liberty. In the law book Release on Bail, Law and Practice, written by one D.C. Pandey from India, it is mentioned under Chapter 2 thereof, and I quote, "The dictionary meaning of the expression bail denotes a security for appearance of a prisoner for his release." Etymologically, the word is derived from an old French verb, bail, which means to give or to deliver, although another view is that its derivation is from Latin term baiulare, meaning to bear a burden, unquote. Just like we all baiulare the previous government. It goes further on to state, and I quote, that the intent of the arrest being only to compel an appearance in court at the return of the writ. That purpose is equally unanswered whether the sheriff detains his person or takes sufficient security for his appearance, called bail, because the defendant is bailed or delivered to his sureties upon their giving security for his appearance, unquote. Bail is accordingly, Madam Speaker, a conditional liberty, and the right to personal liberty is a fundamental right that is enshrined in our Constitution under Section 5 thereof. Bail thus stands at the crossroads of liberty and security between the presumption of innocence and the imperative of justice. However, Madam Speaker, in lieu of upholding this fundamental right of a citizen to be at liberty, this House will recall that in the not-so-past, the then Commissioner of Police disagreed on many occasions with the advice of the Director of Public Prosecutions not to object to the release on bail of several defendants. This situation even led to the Commissioner of Police lodging a plaint before the Supreme Court, the Commissioner of Police versus the Director of Public Prosecutions, SCR number 124745, for constitutional relief pursuant to Section 83, challenging the powers of the DPP with regards to inter alia bail proceedings at investigation stage. Madam Speaker, since the institution of this new government, this House will certainly agree that this conflict has subsided, but to avoid any such conflict occurring again in the future, this bill is being proposed as to amend the Bail Act with a view to delimiting the respective powers of the DPP and those of the CP with regards to matters pertaining to the release on bail of a defendant or detainee, and with a view to bringing about certainty in this area of the law. Madam Speaker, let me now explain to the House how this uncertainty arose. As per Section 44B of the Bail Act, it provides that where immediately after ordering the release of a defendant or detainee, the magistrate is notified by the DPP that an application to set aside his decision is being made before the Supreme Court and that a stay of execution is required, the magistrate shall stay execution of the order and remand defendant or detainee until the Supreme Court determines the application. In other words, Madam Speaker, only the DPP and not the Commissioner of Police has the power to move for a stay of the decision of the magistrate. However, and most surprisingly, Section 44B of the Bail Act further provides that where a magistrate has ordered the release on bail of a defendant or detainee, both the DPP and the Commissioner of Police have the power to make an application before the Supreme Court to set aside the decision to release the defendant or detainee on bail. These aforementioned provisions are not in consonant with each other, as on the one hand, it is only the DPP who has the power to move for a stay of execution of the decision of a magistrate to release a defendant or detainee on bail, while on the other hand, both the DPP and the Commissioner of Police have the power to make an application to the Supreme Court to set aside a decision of a magistrate to release a defendant or detainee on bail. This is absurd, Madam Speaker. If you do not have the power to move for a stay of execution of the decision of a magistrate, which power is conferred precisely to make an application to the Supreme Court to set aside the decision of the magistrate, how can you, when not having the power to move for a stay of execution of the decision of the magistrate, have the power to make an application to the Supreme Court? In fact, this uncertainty in the law has created this situation of conflict. The more so that two authorities cannot have the same powers. I have perused the Hansard debates of the Bail Bill of 1999, and astonishingly, the Bail Bill which was debated in this Assembly did not contain the provisions that I mentioned earlier. In fact, Madam Speaker, these provisions were introduced at committee stage of that bill. Maybe, and I say maybe, when amending the Bail Bill of 1999 at committee stage, a mistake in the drafting of the new provisions may have been made, thus creating that uncertainty in the law. Moreover, the current law grants parallel authority to both Director of Public Prosecutions and the Commissioner of Police to object to bail. The intention was never to create conflict, but to ensure continuity. Therefore, in the absence of the DPP's representative, the police could object to bail based on factual concerns. The DPP, upon reviewing the case and preparing for the hearing, would determine whether the objection was legally justified. If the DPP disagreed, the objection would be withdrawn and the police would abide by this decision. However, recent practice has deviated from this. The then Commissioner of Police has claimed the power to persist in objecting to bail. And even when the DPP, constitutionally entrusted with prosecutorial oversight, considered that there was no legal basis for such opposition. Worse still, the Commissioner of Police engaged the services of lawyers in the private practice to argue that the DPP, cases that the DPP found untenable. This encroachment blurred the lines between investigation and prosecution, two distinct functions assigned by the Constitution to two separate authorities. It led to a toxic situation, one where the police and the apex prosecuting authority were in open conflict, forced into lawsuits against each other, one where public trust in the justice system eroded, as citizens questioned whose orders the police were truly following, one where suspicions of political interference in the detention of citizens became all too justified. With a view to therefore addressing these issues, This bill reinstates the primacy of the DPP in prosecutorial decision-making, ensuring that bail objections are legally sound, free from undue influence, and consistent with the rule of law. Madam Speaker, a magistrate's ruling on bail depends on the objections raised by the prosecution. These objections must be grounded in facts, facts best known to the police, whether an accused has strong family ties that mitigate the risk of evading justice, whether key witnesses remain to be interviewed and need to be protected from interference. These are factual considerations for the police to highlight. As such, Clause 4 of the bill provides that the Commissioner of Police will have the sole discretion not to object to the release on bail of a defendant or detainee before a court. However, where an application is made before a court for the release on bail of a defendant or detainee, and the Commissioner of Police has the intention to object to such release, he shall seek the advice of the Director of Public Prosecutions thereon, and the decision to object or not to object to such release shall rest solely on the DPP. The reasoning to give the DPP that sole discretion is because denying bail is a question of law, one that falls within the competence of the DPP only. Clause 6, Madam Speaker. Clause 6 of the bill further provides that where a magistrate orders the release on bail of a defendant or detainee, the power to apply to the Supreme Court for an order setting aside the determination of the magistrate to release the defendant or detainee on bail shall henceforth rest solely on the DPP in lieu and instead of both the DPP and the Commissioner of Police. In addition, it is being provided in Clause 6 of the bill that where the DPP fails to apply to the Supreme Court for an order setting aside the determination of the magistrate to release a defendant or detainee on bail, not later than 7 days after such an order, the defendant or detainee who had been remanded to custody must on the next day following the expiry of the 7-day period be brought before the court, who shall thereupon release him on bail as originally ordered by the court. Opportunity has also been taken, Madam Speaker, in Clause 3 of the bill to redefine the term detainee, and in Clause 5 of the bill to clarify some bail-related provisions. I wish to inform the House that the office of the DPP and the DPP have been consulted, and he has no objection to the amendments being proposed to the Bail Act. Madam Speaker, I am being tasked, in the absence of my good friend, the Honourable Member, the Attorney General, who is not present, who is unable to come here today, with pronouncing this speech. And I'd like to...
I was actually thinking, I'm sorry, Minister,
Yes.
May I just say a word?
Yes.
I was actually thinking maybe it's important for the record that you should say that you are now acting Attorney General, and it is in that capacity that you're making this speech and that you're going to run through the bill. Thank you. Carry on, please.
This is precisely what I was about to say
received,
at
yes.
this junction. Yes, this is what I was saying. This is what I was about to say now, and this is why I took note here. I'd said I'm being tasked with having to pronounce this speech today in the National Assembly as acting Attorney General. My good friend, the Honourable Attorney General, cannot attend the National Assembly today, and I have spoken to him just before pronouncing the speech and sought further instructions from him. And I'd like to not only thank him, but also thank all the officers at the Attorney General's office and those who have drafted this bill, who have done an excellent job. And I also thank them for having briefed me in the absence of my, I would say, as I would say to a senior counsel, my lineage senior, for pronouncing this speech and presenting this bill to the Assembly. So if I may now go on, the bail is not merely a procedural matter, Madam Speaker. It is a constitutional and societal issue. The right to liberty is sacred, but so too is public confidence in our justice system. This bill reaffirms a fundamental principle, that is the administration of justice must be guided by law, not convenience, and certainly not political influence. The Bail Amendment Bill before the House brings much-needed clarity to a legal framework that in recent times has been clouded by uncertainty and exploited for political ends. Like the recent amendments to the Financial Crimes Commission Act, this bill restores clarity, fairness, and the rule of law. It ensures that decisions on bail are made by those constitutionally entrusted to do so, and that the balance between individual freedom and the pursuit of justice is upheld. With these words, Madam Speaker, I commend this bill to the House.
Yes, who's seconding? Yes. Yes. Honourable Minister, yes.
Thank you, Madam the Speaker. Madam the Speaker, I will be very short since we are dealing with a few amendments to the Bail Act. But I should say this, that although the amendments are few, but they go a long way in showing our determination and our commitment to enhance transparency in the decision-making process of our institutions, and also in reinforcing the powers and the independence of our institutions. And of course, today we are talking about the powers of the police, the Commissioner of Police in particular, and also the DPP's office. Madam the Speaker, we probably don't realize in a very short span of time, we have done so much in restoring the image of our institution. Some of the ministers here will concur with me. We are part of the cabinet, and they know how the Prime Minister and also the Deputy Prime Minister have been working so hard, bringing amendments before this House to restore the image of our institution. The image, our institutions, we are talking about institutions having constitutional status, not parastatal bodies, not institutions under ministry, but we are talking here about very important institutions which are in our constitution. And the population has witnessed that as soon as we have come in power, the Prime Minister has brought in very important amendments in order to restore the image of these institutions. Madam the Speaker, this Parliament is a vivid example. Your nomination as Speaker, you are shining in the chair, Madam the Speaker. And votre rayonnement est en train d'éclairer les débats dans cette chambre. And you just for 1 minute, just compare. I was in this house. Just for 1 minute. Just compare how the debates are going on now and compare it to the 10 last years. I mean, but sometimes it's good. I know in the previous debates, orators have been speaking about it, but it's important that we repeat it and repeat it again, because we don't want this to happen again to our democracy. Récemment, là, on a apporté les amendements. The Financial Crime Commission Amendment Bill was introduced. Once again, in order to bring transparency afin de restaurer la crédibilité et l'indépendance du DPP on cases with regards to corruption and anti-money laundering. Madame la Présidente, il y a plusieurs exemples where this government has had to intervene, as I've said, in a very short span of time to bring in corrective measures. The police force is another example. Qu'est-ce qu'on n'a pas vu? Qu'est-ce qu'on n'a pas témoigné sous l'ancien régime par rapport au commissaire de police? Today, we have a new commissioner who is rebuilding the trust of the people in the police force. Never in the history of our country have we witnessed our institutions being so undermined, their image tarnished by a government, as has been the case over the past 10 years. And as I've said, and I repeat it because it is important that people know, we are not talking about minor institutions. We are talking about very important institutions that have constitutional status. Madame la Présidente, when the drafters of our constitution, our past political leaders, they were sitting in Lancaster House trying to bring in propositions to consolidate our constitution. Mettez des garde-fous so that they can secure the independence of our institution. There was a reason behind that. Because they wanted that the population should have trust in our constitution. The population should have trust in our institutions. These were the reasons why they had imposed garde-fou. They wanted that the institutions not only operate in independence, but also seen to be operating in independence. Madame la Présidente, on parlait à cette époque, if you go through the procès verbal de ces comités, you will see that they were even talking about, at that time, the Queen appointing the Commissioner of Police. Because they wanted that these institutions should have the independence that is required, so that the people can trust these institutions. Mais malheureusement, sous l'ancien régime, ça n'a pas été le cas. Pour commencer, by starting from the top, la présidence, Madame la Présidente. La présidence, there was a mistrust between the President at that time and the Prime Minister. L'affaire Sobrino. La Présidente de la République a même institué une commission d'enquête ratée, without consultation from the cabinet of ministers. Et puis ça, elle s'est retrouvée elle-même face à une commission d'enquête. And so there was that mistrust between the two institutions, and c'est comique, mais we could have ended up in an institutional clash between two very high institutions in our constitution, la présidente de la République et le bureau du Premier ministre. Vous imaginez? there was also the Commissioner of Police. You remember, the Commissioner of Police was placed on probation. Even the head of the CID, he also was in contract, and they were being used to arrest political opponents. Madam the Speaker, there was also the recommendation of the Commission on the Prerogative of Mercy. I remember the case of the son of the former Commissioner of Police, wiping out a conviction of 12-month imprisonment without any reasons and in total opacity. This is how our institutions were functioning at that time. The political appointment of political agents and the Electoral Supervisory Commission and the Electoral Boundaries Commission shows a blatant disrespect that the previous government had to the independence of these constitutional creatures. Madame la Présidente, with regard to this
bill
act, similarly back in 1999, the Labour Party had brought a new bail act, right? And they made, when the act was passed, the idea was to make the granting of bail the rule and the objecting to bail the exception. But again, little did we know that we would have a former Commissioner of Police who would usurp the powers of the DPP and refuse bail, as explained by the acting Attorney General, in cases where there were political opponents. And this even resulted in an institutional clash between the police, the Commissioner of Police, and the DPP's office, resulting in court cases before our courts of law. And this is why, Madam the Speaker, we are having to intervene today, once again, in order to bring back trust in our Constitution, in our institutions that have constitutional status, by defining with clarity the powers of the Commissioner of Police and the powers of the DPP when it comes to bail applications. Thank you.
Thank you so much. Yes, Honourable Junior Minister.
Merci, Madame la Présidente.
Junior Minister, if I may, try and speak a bit about the bill, please.
Okay, fine. Madame la Présidente, comme les deux honorables ministres qui m'ont précédé, je ne suis ni avocate et je n'ai aucune bagage juridique. Je m'adresse à cette auguste assemblée sur le Bail Amendment Bill en étant qu'une citoyenne concernée et engagée avec ce présent gouvernement pour promouvoir l'espace démocratique dans le respect de la Constitution et de notre État de droit. Madame la Présidente, je constate que l'honorable Adrien Duval du PMSD et l'honorable leader de l'opposition ne se sont pas engagés à prendre la parole sur cet important projet de loi. Je comprends que le MSM ne participe pas car durant le parcours de ces 10 dernières années, ils ont torpillé le bureau du DPP. Mais l'honorable Adrien Duval et le PMSD ne participent pas. C'est la preuve de ce qui est devenu et de ce qui reste du PMSD en termes de respect et d'importance accordée au mot démocratie et du bureau du DPP. Madame la Présidente, notre pays a traversé une grave crise institutionnelle. Nos institutions étaient gangrénées, pourries par le gouvernement MSM sans scrupules, avec la complicité d'un commissaire de police corrompu qui a abusé de ses pouvoirs
pour des fins politiques. Ce commissaire n'était rien d'autre qu'une marionnette entre les mains du couple Jugnut, dont la toxicité a empoisonné nos institutions. Madame la Présidente, dans cette force policière, la compétence, l'expérience n'étaient plus critères de promotion. Ce qu'il fallait, tout simplement, participer dans des cover-up ou simplement une simple application de gel. C'est écœurant, dégradant et tout simplement honteux, Madame la Présidente. La police, qui est censée nous protéger, était devenue un motif de peur. Poursuites fabriquées, planting, arrestations sélectives, abus du recours aux charges provisoires, un climat d'oppression s'est installé. Et nous en avons été profondément choqués d'apprendre qu'il existait dans nos rangs des policiers tortionnaires, Madame la Présidente, oui, tortionnaires. Ceux qui ont torturé, humilié des prisonniers en utilisant des tasers sur leur partie intime. Ce sont des actes inhumains et j'espère sincèrement qu'ils paieront très bientôt pour leurs crimes, Madame la Présidente. Notre pays était devenu un véritable État policier au service d'une police politique dirigée par le MSM. Madame la Présidente, dans tout cela, notre seul rempart était et reste le judiciaire. Heureusement, 2 femmes magistrates qui ont su redonner espoir à notre système judiciaire. Face aux pressions politiques, elles ont tenu bon. Avec conviction, je parle là des cas Kisnen et de Bruno Lorette. Madam Speaker, we must also reflect on the disgraceful and unprecedented attack on judicial independence made by the former Prime Minister, who had the audacity to call a court ruling, and I quote, un gisement bancal. This shocking statement exposed the MSM utter disregard for the judiciary. It is disgraceful coming from a so-called lawyer. Today, in stark contrast, the current Prime Minister and Deputy Prime Minister have given a lesson in governance by not interfering in his case when he was arrested by the FCC, even when the public will wanted to see him behind the bars. Madame la Présidente, regardons dans le rétroviseur. Le MSM a toujours voulu contrôler le DPP. Souvenons-nous de la fameuse Prosecution Commission en 2016 qui a mené à la démission du PMSD grâce à des experts en droit qui ont su éclairer son leader sur les dangers de cette loi. Je tiens à remercier chaleureusement l'un d'entre eux qui, bien en n'étant même pas membre du PMSD, a agi par conviction profonde pour la démocratie et l'indépendance judiciaire. C'est l'honorable Kuchal Lobin. Madame la Présidente, je saisis cette occasion pour saluer l'honorable Adrien Duval, qui fut le premier à démissionner à cause de cette dérive. Mais hélas, quelques années plus tard, il a oublié son combat et s'est précipité, aveuglé par le pouvoir ou peut-être l'argent, pour aller s'asseoir sur la chaise du speaker, du loud speaker. Le pauvre lui-même ne savait pas qu'il a été démissionné par le Premier ministre. Putting my son first, telle a toujours été la devise du leader du PMSD. C'est pour cela qu'il est le seul à avoir échappé à la colère populaire. En sacrifiant des piliers comme Oro Perro, qui a tant travaillé dans la circonscription numéro 4, et bien d'autres compagnons jetés comme des pions, comme on dit en créole, dans Carocan. Je suis fière d'avoir été la première à quitter ce parti et fière aussi de l'honorable Richard Duval et de l'honorable Kouchal Lobine, qui ont eux aussi quitté ce navire pour fonder ensemble, avec d'autres amis, les Nouveaux démocrates, un parti d'avenir. Madame la Présidente, je félicite notre Attorney General. Depuis sa nomination, il n'a pas eu un jour de répit. Il a travaillé sans relâche sur plusieurs amendements pour restaurer la démocratie et redonner son indépendance au judiciaire et au DPP. Je sais qu'il n'a pas eu le luxe de déguster du sanglier ou de chipper un Blue au Stack Party comme son prédécesseur. Madam Speaker, I would like to express my strong support to the Bail Amendment Bill, a crucial legislative reform brought forward by this government. This bill ensures that the DPP alone has the final say on the prosecution matters, free from any interference. It removes the Commissioner of Police abilities independently object to bail, making it crystal clear that only the DPP can challenge a bail decision before the Supreme Court. With this bill, we send an unmistakable message. Never again will a government be able to manipulate the DPP's office for political ends. Never again will the police be turned into a political weapon. Never again will the judiciary be undermined for the sake of power. Madame la Présidente, notre pays a traversé une grave crise institutionnelle. Nos institutions ont été engrainées, comme je vous ai dit, mais grâce à cet amendement, aujourd'hui, on va retrouver la liberté et l'indépendance de notre système judiciaire. To conclude, Madam Speaker, I would like to quote George Herbert, "Where there is a will, there is a way." Madam Speaker, today, in this House, we have the will, we have the competence, we have the motivation, the quality, and the quantity. And under the guidance of our Prime Minister and Deputy Prime Minister, we are on the right path to make Mauritius be Mauritius again. Thank you, Madam Speaker.
Honourable Junior Minister, thank you. I would like you to be careful and perhaps withdraw one part of your speech, because you're talking about Honourable Duval, who maybe is not present, but he's a member of the House. And I don't think you're allowed to impute motives when you said that part, that maybe, you know what I mean, maybe he did it for money. That would be imputing motives. We don't want to open a debate later on this issue. If you would please kindly withdraw that part.
I will do it, Madam Speaker.
Thank you. Yes, now I have Mr. Babula.
Thank you, Madam Speaker. The Bail Amendment Bill is indeed clarifying the powers of the DPP and the Commissioner of Police. Madam Speaker, the Republic of Mauritius is a democratic state, and the Constitution is the supreme law. The Constitution guarantees our fundamental rights and freedom of the individual. Section 5 of the Constitution embodies the protection of right and personal liberty. Madam Speaker, the right to liberty of an individual is enshrined in Section 5.3 of our Constitution and is reflected in Section 3 of the Bail Act 1999, which provides that notwithstanding any other enactment and subject to Section 4, every defendant or detainee shall be entitled to be released on bail. In considering any application, the learned magistrate bears in mind the fundamental constitutional principle that freedom is the rule and detention on account of reasonable suspicion the exception, and must see to it that bail is not being withheld as a form of punishment. Madam Speaker, on the other hand, the Director of Public Prosecutions derived his powers under Section 72 of the Constitution. Section 72(6) states that in the exercise of the powers conferred upon him, by this section, the DPP shall not be subject to the direction or control of any other person or authority. Whereas the Commissioner of Police powers are vested in him by Section 71 of the Constitution. Madam Speaker, this bill presented by the Honorable Attorney General is a clear sign that the liberty of the people that they voted for on the 10th of November 2024 will always be respected. And this government is doing its best to restore democracy. Madam Speaker, the previous government was a fake one. We had a fake Prime Minister, a fake Speaker, and not forgetting the fake Commissioner of Police, where power was abused upon the citizens of this country. People were scared because the kitchen could strike at any time with its striking team. And even when the judiciary were protecting the rights of the citizens, as per the Constitution and the laws of this land, all kinds of loopholes were circumvented to oppress people and control their liberty. One of them is the Bail Act, as rightly pointed out by the Honorable Acting Attorney General, Section 4B, 4A of the Bail Act. Previously, this was not the case. This law has been here since long, but all has started when the Commissioner of Police want to control everything. Madam Speaker, the case of Bruno Lorette is a clear-cut case to explain how the CP wanted to control everything. Honorable Minister Shakil Mohammed, who is presenting the bill today, was his barrister. He stated at that time, le commissaire de police n'a pas le locus standi, selon la loi, pour entrer une telle action. That was at that time. Madam Speaker, the Commissioner of Police wanted to attempt a kind of constitutional revolution that would make the CP the one who would hold the power of release to or detain a suspect alone. The case of Akil Bisesar. This explains why this bill is necessary. What happened in the case of Akil Bisesar? He was arrested by the striking team. He was presented before a court of law. His counsel put a motion for his release on bail. And the Commissioner of Police asked for the DPP to be present on that day. And when the state law officer was present on that day, he stated that there was no objection for his release. And what happened? This is on that day, Madam Speaker, the fake government and the fake Commissioner of Police was not happy. They had to do everything in their capacity to prevent this release. Everything was done to please Pinocchio because he nominates the CP. Madam Speaker, this has never happened before in Mauritius in any court of law. Nor did the police prosecutor say a word. But what happened? The Superintendent of Police, Mr. Gangadin, made the following statement on the floor of the court. He states, the CP is abroad in France, and prior from leaving the country on Saturday, he was formally instructed to attend court today in virtue of the constitutional powers vested upon him. He has instructed me that if the DPP goes against police instruction, then for the police to object and mention his stand, that if he need be, the office of the CP will solicit help from outside of the DPP's office. He states that this is interference of the DPP. And guess on whom the Commissioner of Police placed his bet in this case? Is none other than Mr. Yerigadu, who knows how to play, and Mrs. Sonauri, the Prime Minister's attorney, looting again the taxpayers' money from the back door. The Commissioner of Police feel aggrieved in the manner in which the DPP appears to have usurped the CP's power. which was never his power in any way. He filed 6 grounds before the Supreme Court. All these grounds failed, Madam Speaker, on the preliminary objections raised by the counsel for Mr. Akil Bisesar. The powers in relation to the Supreme Court, Madam Speaker, in relation to the case of Rangasamy and the DPP, the full bench of the Supreme Court considered the jurisdictional basis to review any decision of any subordinate court in criminal matters. It is twice law that a review envisaged under the Section 44A of the Bail Act and Section 82(1) of the Constitution entails a re-hearing of the Supreme Court. Even though in the case of Bisesar there was no ruling, still the Machiavellic team tried to challenge the learned magistrate and the DPP. Madam Speaker, the fake CP was willing to improvise a disguised way of challenging the constitutional powers of that the DPP holds, and wanted to hold the power to arrest, release, and detain a suspect. Now the amendment bill will amend the Bail Act so as to delimit the respective powers of the DPP and those of the Commissioner of Police. Madam Speaker, the DPP will be the only one to decide whether to object or not for the release of a detainee, and also the power to apply to the Supreme Court for an order setting aside the determination of the magistrate to the release of the detainee on bail. This government will make sure that the rights and freedom of the citizens are respected and the rule of law prevails, and that where the DPP will continue to enjoy the constitutional powers entrusted to him as guaranteed by the Constitution. I commend the bill to the House, Madam Speaker. Thank you.
Thank you. Yes. Ms. Béranger? No? You want a break? Okay. I'm so sorry. I am in the hands of everybody. I think everybody wants to go for tea. Let's break. Vous ne perdez rien à attendre. Okay, let us break. On aurait pu la laisser.